You're okay.
I know that's the prosecutor's, but I'm assuming he left it there, so.
Good afternoon, Your Honor. Again, for the record, Daniel Land, appearing on behalf of the plaintiff.
All right, would you guys need motion to defend myself?
Thank you. And today was the date that we proceeded with a bench trial. We have the plaintiff's issue of being non-payment of rent in the amount, I think, balance of $17,005.03, not including cost and statutory attorney fee. And Ms. Milton filed a counter complaint alleging a breach of warranty of habitability, as well as plaintiff's lack of valid rental certificate and a claim for lockout. The court heard testimony and received exhibits today. I'm first going to address your counterclaim, because I don't think it's disputed that you have not paid any rent for the times alleged. Your allegations is that you withheld the rent due to your belief that there was a breach of the habitability issue. And in reviewing that evidence, I see, or we received a memo that was presented by the plaintiff that was to reflect, I guess, when calls were made. It doesn't look like it's an exhaustive memo, but it shows that at least sometimes when calls are made or memos are sent out, that it's documented here in the plaintiff's exhibit 4. And I say it doesn't appear to be exhaustive because I can see where it indicates that there may have been some other calls that may not have resulted in being placed on this memo. But there is, as it relates to the habitability claim, a note from August 15, 2022, which would be shortly after the time Ms. Milton moved into the alleged property, that she called stating that she was upset with her townhome on the day she moved in, and that she would not be paying rent until her townhome gets fixed. Doesn't really give specifications as to what was or needed to be fixed. I did, however, review in plaintiff's exhibit 2, work order number 173498, and that describes or provides a description of property issues, that being a patio, screen door doesn't slide, hallway, bathroom sink, on the second bathroom lifts, out of cabinet, ceiling needs covering, in laundry room, sink leaks and smells bad, unleveled floor in the second bathroom, all toilet seats are broken, smoke residue on walls and vents, new filters for furnace, second bedroom sliding mirror is broken, new blinds for kitchen and all bathrooms, and then leaking toilet in the upstairs bathroom to the right. It's noted here, I noted at least, that it states that the requests were not addressed until October 14, 2022. That would be a couple months after the request. There was a technician note, however, that stated there were 3 visits and they were not going back because they were asked to leave every time. I don't see any indications of if there were 3 visits, what were the other dates that they appeared in those times. I don't have any notes, but primarily I don't have anybody who sat in that seat there to testify as to what happened when that took place. And the witness that did testify on behalf of the plaintiff was not in a position to give testimony to rebut the defendant's claim that she never denied entry, canceled the request, and or asked anyone to leave. And so I have to take her testimony, which she gave under oath, which is that she didn't ask these things, the leave, and she didn't prohibit them from come in to complete the work order. It's stated here, however, that it was completed on that date. I will move forward to the next work order that was attached to that exhibit, which is a call for August 25th, which would have been 6 days prior to the one on the beginning of this exhibit. The same exact problems were described. She did okay their entry. It states here, though, that the request was canceled. It says September 22nd, 2022. The defendant under oath denied that it was canceled. There was no testimony or anybody present to rebut that statement that she didn't deny their entry to fix the problems that she had reported previously. I have a exhibit from the plaintiff, exhibit 3. It gives a call date of September 13th, in which the problem described was that her heat was not working. I see there was a technician note. It says that the motherboard is bad. Order new part. Should be here by Friday. Will install then. It's interesting because the date of this note was on the 13th, which is the same date she called, but it stated that it was completed on the 13th, an hour before that. So I wasn't clear as to how was this completed if a part needed to be ordered and it would not be installed and the issue would not be addressed until that part was delivered. And then it shows that it was canceled on the 22nd of September. And if there's a request or a concern that there's no heat, I don't know how that could be canceled. I do see a note again on the technician side, installed new board, flame sensor bad. So again, lots of questions and concerns about what that means, because if the flame sensor is bad after he installed new board, then wouldn't that mean that it's still broken? But I didn't have anybody here to testify to that. So I have to take the defendant's word that it was still an issue. And then we move forward to the next work order, which is a call date for November 8th at 12:31. Still, the issue is heat is not working. Then there's a leaking sink and other issues that are identical to the complaints that were made back on the August and September work order requests. The report from, I believe it's Bill Eck, that might be the same person that reported the last time, stated that he checked out the furnace. It is working correctly. The furnace was off at the thermostat. And then it addresses some other issues as regards to the leak in the kitchen and tightening that so there's no longer a leak. Not sure why he's putting why he's yelling with exclamation points in the notes. Washing machine works perfectly. Dryer needs to be replaced. We heard some testimony from the plaintiff's witness that the dryer was not replaced due to a balance, but also testimony that she was not in the position to tell what the measure was as to what gets replaced, what doesn't get replaced if there's a balance, because she would not be the appropriate witness to testify. She's not the appropriate witness to testify as to any of these allegations as to habitability. I think there were some maintenance people here. I don't know why they were not called, but that was the plaintiff's choice not to call those witnesses. And I don't know. There was no witness as to who could testify as to how the furnace was checked, because the previous exhibit stated that there was a flame issue. We don't know what was checked. The defendant testified under oath that the thermostat was not broken and that she turned the thermostat off because the heat was not working and she was trying to conserve her bill. So again, nothing to rebut that. as it relates to evidence. There is a November 22nd call date, the issue being some outlets in the living room not working. I don't see anything about the heat at that point. I do see a December 14th work order, which again, looks like the problems were a cut and paste from the first August 31st, 2022 requesting the exact same things are being requested there. So as to indicate that those had not been addressed. I don't see. Any further work orders? Oh, there's one more work order, and that would have been from April 3rd, and it was about the ceiling pavement in the basement. I'm unclear as to whether or not that is related to the allegation of the leak in the pipe explosion, but it's possible. But again, I don't have anybody from maintenance or anybody who could testify as to that. As it relates to habitability, I think that the first list of issues presented in that first August 31st work order, they're concerning, and I'm sure they cause some frustration. I don't think those issues in and of itself would lend to abatement of your rent, or for you to believe that the warranty of habitability was breached at that time. However, I believe once that issue of the furnace was factored in, and that doesn't take place until September, there's a concern. And that we live in Michigan, so you can't live in a property without a working furnace. And we need to know that the furnace works and that it heats above a certain temperature. Not that we just went in there and turned it on and it looks like it works. I looked at the time that the person was, the maintenance person put on here that they actually was in the property. It wasn't very long. And they managed to get all of these things done, including checking the furnace. And then I don't have anybody here to ask or for us to question as to what they did to check the furnace to ensure that it was in proper working order. Therefore, I'm not satisfied that the furnace was in proper working order when they went to check, because I don't have anything to rebut that other in her statements under oath for that it still was not working. She then indicates that because of the issue, she put her rent into escrow. I don't have any evidence of escrow. She stated it's in a private account. That information, although there was no evidence presented in the court, there was a testimony about it, I believe. It doesn't comport with the requirements for escrow. And as Mr. Landman stated in his argument, you are required, if you're going to escrow rent, to notify the landlord of the account and where that money is being held, so that they can verify that you're escrowing this money, you're holding this money so that they can address an issue, but you are ready and willing to pay your rent. It's to show good faith. And you did not do those things. However, I do believe there was a concern or breach, at least for a period of time. I don't believe the breach was the entire time. And I do believe that if in fact the breach did extend the entire time, or at least from the time that I'm going to construe it from September 13th, which is the date you put them on notice. If it extended up until today's date, I believe you had a duty to mitigate at a certain time frame. That means if you're going to leave this property, you need to make some efforts to then either bring them before the court to require them to get this fixed, or you're going to remove yourself from the property and request to have your lease terminated, but that you're not just holding over a property that you claim that you can't live in. That's not meaningful for you, and it's not meaningful for them. It's just creating ongoing contentious action for no reason. And so as it relates to the habitability, I am going to grant your request for a certain portion, and we'll get into that portion in just a moment. I want to address your other counterclaims. There was a allegation in the counterclaim for a lack of rental certificate, which we clarified on the record. You actually meant, or it should be construed as invalid contract. You believe the contract was invalid, and that was due to the fact that your lease states one address is at 4730, and you actually are residing in 4732, or that's at least the key that you received. Based on my interpretation of the law, I am construing your lease to be valid because although there was that issue with the numbering, you didn't, and I questioned you about this. You didn't go and look at a specific unit and contract for that specific unit. You contracted for a townhome, and you were notified prior to that they were switching your unit, and you accepted the key for that unit. And so that creates at minimum tenancy at will because of your implied consent at that time. And so I do find your lease to be valid. And then as it relates to your other claim that you were locked out, I think you conceded on the record that you were never locked out of the property. You really just wanted to make sure that you were not locked out of the property during that time. And so as it relates to what I believe is reasonable based on the issues that you dealt with in this property, by the time you found out or at least notified them that your furnace was not working, your September rent should have been paid. And so you will not get an abatement for September. October, they were on notice, and I don't see any record or have any evidence to support that the furnace was addressed or repaired. November, I don't have any record to support that the furnace was repaired. In December, I don't have any record to support that it was repaired. I'm going to credit you those 3 months in full. Now, January to now, the concern I have is you've been served with a notice to vacate. You had time to file a counterclaim at this point, alleging the things that you stated were going on. I don't believe we got a counterclaim filed at that time, but you were, at least as it states in the counterclaim, staying in a hotel. I'm willing to abate you for the cost of those hotels. I need receipts or proof of those hotel amounts. And that will be deducted from your rent for the months of January to the present time. But you will be held responsible for holding over the property during those times because you had a duty to mitigate damages under the law, okay? Do you have any of that evidence with you today as it relates to the amounts of the hotels? If you do not, I can adjourn and we'll reconvene so you can get that to me so that I can get a final amount. You do have it with you? Okay, that's fine. We only need one copy. What was the monthly rent? 12. Oh, let me see. 15, correct? Is that correct? Her rent is 1520?
That's correct.
Okay, and she was charged late fees for the months of October, November, and December. Those will be abated as well. I know he'll get them from you. Can you get that form from her, John? Thank you. Mr. Lamon, did you want to review these before I calculate them?
I would like to, yes. Your Honor, the only thing that I would note with respect to what's been presented is it looks like the last 2 pages are the same event. So,
Yeah, I was gonna go by the dates.
so I have totaled, we'll see if my total matches up with yours. But it does appear that the last 2 pages reference the same invoice.
Okay, and then what were the late fees? Because I see late charges multiple times on here. On this ledger.
Here, would you be able to verify that the room numbers are different on both of those that have the same?
I don't have them. I think he has them. So. You said the room number is different?
No, it's
Yeah,
room
yeah,
3, it's room 333, it's the
verify.
same room.
Oh. Can you tell me what the late fees were for the months of October, November, December? Oh, no, I need those back, Sean. I'm sorry.
Shoot. Sorry.
Thanks.
Yes, Your Honor. Total late charges for October were $112. Total late charges for November were $110. Total late charges for December were $112.
Okay, I have receipts for 12 days of hotels. I'm also going to credit you because you had to eat while you were in these hotels. And it was you and 4 children?
Yes, ma'am.
I'll give you a credit of $900 for having to supply food and resources for your children during those 12 days. That's $75 per night, okay?
Yeah.
I totaled the abatement of rent plus the hotel costs to be $6,367.16. Is that with the math? Is that the math you got, Mr. Layman?
No, it's not. I have 1520 for October, 1520 for November, 1520 for December,
In late fees.
324 late fees,
Let me see.
900 for food, and I had 1,473.16. So I have 7257.16. Does that match up?
Yeah, I think when I give, the number I gave you did not have the 900. Let me see, 202.88. I have, wait, what did you have again?
7257.16
That's
cents.
what I got. Okay, is that what you got, Ms. Milton?
Yes, ma'am. Yes, ma'am.
Okay, that'll be the total abatement of the amount of fines and costs I am gonna fine for possession for the plaintiff. And so their total damages was 17,005.03 plus costs. I don't know what your costs are.
Total cost, Your Honor, are 167.50.
So you had 17. Plus one, give me that again.
It's 167.50.
Have 17,172.53. Is that what you have total?
Yes.
Okay, minus the abatement. Brings $9,915.
And 37 cents.
Correct. That's what I did. Final number, $9,915.37. Okay, so that will be the final judgment of the court. Can you get me an order? Oh, you have an order.
I do, Your Honor.
Okay, perfect. So you want to let her review before I
Sure.
sign it?
Your Honor, I calculate the statutory time period of giving a tenant through July 5th.
Okay. Ma'am, how much time do you need to get out of their property?
I'm sorry.
How much time do you need to get out of their property?
With it being the holiday, can I get to that Friday?
Okay, Friday is July 7th.
July 7th.
I'm gonna give you actually to the 10th.
Thank you, Your Honor.
It's your estate, okay. Any additional matters for the record today, council?
Madam, just for the record, I will object to the July 10th move out only because another month's rent's going to come due. And obviously that's not.
Thank you. Well, the rent came due before the 3rd anyways. The first of the month is what her lease says. So objection is noted. Any additional matters from you, ma'am?
Do I get further paperwork on how the rest of the proceedings go?
How what?
The rest, amounts owed, I'll get further paperwork to set up stuff with them.
You can make a payment or arrangement with them, or you can seek for installment payments. You'll file paperwork for that, okay?
And I will hear from their attorney on the abatement, or is that through the court?
No, the abatement is already listed in here. So they were saying that you owed 17,001 and some change, and it's now down to 9,000, okay?
Your Honor, before the judgment's handed out, I just realized there's nothing, I didn't note anything on the judgment relating to the dismissal of the counterclaim. And I think under other items, we should note the counterclaim. Either there's a judgment of no cause of action on the counterclaim, or the counterclaim is dismissed with prejudice.
Dismissing count 2 and 3 of counterclaim. Are you ready for something else? I don't have it.
Just waiting to be released, Your Honor.
Oh, yeah, you're free to go. Thank you.
Thank you, Your Honor. Have a good afternoon.
You too.
Thank you, Your Honor.
Thank you. Are you ready, Mr. Abbott?
Yes, Your Honor, we've come to an agreement in the meeting minutes since I spoke to you.
Times since changed so drastically.
Indeed, we'll be entering a plea with mystery.
Okay, sounds good. Let's see. Yes, please.
We're ready though too.
Oh, I can't see who's behind there. Oh, it's
Me.
Mr. Meltz. He can wait.
Skulking once again.
Yeah, we're the only ones in, was it?
Yeah.
Jail cell downstairs.
Well, I was wondering too.
Yeah, that was, we, there.
TV second.
It was disturbing.
Yes.
Sure.
Part of that, I moved to the-
Okay. Should be a plea, Your Honor.
You're yours.
I forgot.
I'm gonna run this down to civil. Mr. Murray's being brought up by security.
Sounds good, thank you.
Sir.
Should we put anyone there? Huh? I was like, why am I? Yeah,
You want me to, okay.
stressed me out.
Sir?
You got the list of meetings for next week.
She does.
Oh, she sent in the email? Yeah. She sent it in.
I can see a couple breadcrumbs in there, but.
And they're not doing the annual meeting on my birthday this time. Oh, that's good. Right. Moving up. Okay. Murray's green. Oh, no, it was the other guy. That's what I was saying. That's interesting. On the record in the matter of the people of the state of Michigan versus George Spataro. Spataro?
Yes,
Okay,
everybody does it.
Mrs. Spataro, file number 23 dash. Does he have another file number? Because that's not the file number.
1248, is that?
It's signed for 231786. Oh, okay. I have 23-01248. That's what we're here for today, correct?
Correct.
Okay. I just wanted to make sure you didn't want to plead on another file that I need to grab. That's just the wrong number.
Let's find out what the charge is.
Sounds good. I'll cross that out.
Yes,
No, you're right.
please.
That is correct. If we could change the number.
Sounds good. Council appearance.
Stephen Milks, Your Honor, on behalf of Mr. Sparrow, who is present and standing to my right at this time, Your Honor.
Thank you, Honor. Dale Coulter here on behalf of the court.
Okay, today was the date set for a preliminary examination. I have a plea sheet that people are offering for you to plead guilty to aggravated domestic violence under MCL 750.8182, misdemeanor maximum penalty, 1 year and $2,000 in fines, and the people have no objection to sentencing under 769.4A. And there's an issue of restitution that's going to be reserved, that's correct?
That is correct.
Okay. There's a killer brew of no upfront jail as well. Is that what you recall your offer to be? You want to accept that offer today, sir?
Yes,
Please raise your right hand. Please. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
yes,
Thank you. You can put your hand down. And do you have an advice of rights and plea information sheet? That's your name on there, sir?
yes,
And you signed that?
yes,
Okay, did you read this document?
yes,
You understand the rights here?
understood, yes.
Do you have any questions about these rights?
No, ma'am,
You're willing to give up all of these rights in order to accept the offer?
yes,
So you understand that you have to give up your right to have a trial, and you have the right to a jury trial?
yes,
You have the right to the presumption of innocence at the time of your trial, and you want to waive that as well?
yes,
So that means you're gonna waive your right to be innocent until the prosecution proves you guilty. You have the right to have them prove you guilty by proving each element of the charge being brought against you beyond a reasonable doubt at a trial. You wanna waive that right?
yes,
You wanna waive your right to remain silent at trial and not have silence be used against you.
yes,
You wanna waive your right to cross-examine or question any other witnesses that the prosecution intended to call against you.
yes,
Okay, anybody threatening you or making any promises to you in exchange for your guilty plea today?
no,
Are you currently on probation or parole?
No.
You understand that a guilty plea can result in a conviction that you may need to report to your employer or put on a future job application that you have a conviction?
yes,
You understand that a guilty plea could have impact on any travel or immigration status you may be seeking?
yes,
There's a killer brew, and that's agreement between you and the prosecutor. I'm not a party to that. Did Mr. Milks explain that to you?
yes,
Okay, so you understand that if at the time of your sentencing, if I determine that I think it's best that you do go to jail, I'll give you the right then to withdraw your plea, okay? Okay, and are you entering a plea, a guilty plea because you believe you're guilty?
yes,
Okay, as to the added count of aggravated domestic violence, how do you plead?
guilty,
Can I have a factual basis, please, counsel?
Yes, thank you, Your Honor. Okay, George, I'm just gonna ask you some questions that we kind of went over earlier, okay? So on or about March 27th, 2023, at or near 2905 South Washington in Lansing, Ingham County, were you there with your sister, Linda Spataro?
yes,
And that evening, had the two of you gotten into a verbal altercation?
yes,
And it said you had an argument, is that right?
yes,
And that argument eventually turned physical, is that correct?
yes,
During that physical altercation, did there come a time where you put your hand on her throat?
yes,
And did you squeeze?
yes,
And you would understand that that would lead to choking or difficulty breathing, is that right?
yes,
And did you do this in self-defense?
No.
Your Honor, if that would suffice.
Any questions?
Just one question. Sir, at the time that this happened, were you living at that house?
yes,
That's the question.
If the court is satisfied with the factual basis, I'll accept your plea, find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing. Sentencing is going to be August 18th, 2023 at 8:30 in the morning. Prior to sentencing, you need to meet with probation. So when you leave here, you should go down to the 5th floor and meet with our probation department. They have paperwork for you to complete so that you can get set up for a pre-sentence interview, okay?
yes, yes.
Okay. And then you can appear in person or by Zoom for your sentencing. If you are going to appear via Zoom, you need to make sure you'll be in person. Okay, so then we don't need to go over the requirements to appear via Zoom. Do you have any questions today?
No, ma'am,
Okay, any additional matters for the record today, counsel?
I have one, Your Honor. Regarding the no contact order and restitution, my client, restitution involves a TV that was destroyed. My client has bought a TV and he would like to give that, if that would suffice to the victim in this matter. I spoke with Mr. Cultrider as well. He believes this would suffice after speaking with the complaining witness in this matter. At least that's my understanding. Would the court allow third-party contact only for the purpose of that TV to be delivered?
We would agree. She wants to look at the TV.
Is
She
the
just wants to
complaining
make sure
witness
it
here?
isn't broken or something.
Is this
like
the complaining witness?
Yes.
She's shaking her head.
Well, I'm gonna say no, and so I question it.
Okay. Is she gonna, are you sure she's gonna take the TV or she wants to inspect it first?
Well, she would take the TV if there's nothing wrong with it and if it's equivalent to what was broken.
Sounds reasonable.
Correct.
And they could be bigger ones.
Okay. Okay, I'll let you all work that out. And if she agrees, then third-party contact will be allowed for the purposes of delivering the restitution.
Thank you, Your Honor.
No problem. Any additional matters?
Not from the people.
Not from the fence, thank you.
Thank you.
Oh, quickly.
When you're right, you're right.
Okay, are we ready? Mr. Murray? We're on the record in the matter of the people of the state of Michigan versus Jason Ray Murray, file number 23-01476 FY, council appearance.
Andrew Stevens on behalf of the people.
Good afternoon, Your Honor. John Abbott representing Jason Murray. And Your Honor, I should inform the court that I misrepresented his intention. And didn't give him enough misrepresenting. He's not going to plead.
I was gonna say, even if he said he was, he changed his mind.
And
So are we running an exam? Okay.
Your Honor, at this point, the people are unable to proceed as the complaining witness has not appeared. With that, I anticipate a motion from Mr. Abbott, to which I have no additional response.
Move to dismiss. Your Honor.
Motion to dismiss without prejudice is granted. That means that the people do have the right to reissue the charge against you if the necessary witness appears and is ready to proceed, okay? I'm sorry,
Yes, ma'am.
do you have any questions at this time?
No, ma'am.
Okay, any additional matters for the record?
Nothing from the people. Thank you.
Anything else?
Thank you.
Thank you.
Thank you, Your Honor.
We'll get you a copy of their Nolly. Is this step two? Okay.
I'm kind of glad I made his day today because he looks very scary.
I wouldn't want to know that.